Our final speaker this evening is Greg Barnes, SC. Greg is a barrister, writer and former political advisor. He has been advisor to the Australian Assange campaign and a former chair of the Australian Republican movement. Greg will be discussing the impact on human rights. Greg, thank you. You have the floor.
Thanks, Kelly. Well, thanks to all other speakers, and I also acknowledge that I am speaking from stolen land, unceded land, and in my case in Nipaluna, Hobart. I'm going to talk a little bit about the issue of the legal issues and the human rights issues which emerge from Australia's ties with the United States, and in particular consequences of AUKUS. And I think one of the most fundamental issues is the issue of freedom of speech and freedom of the press. We've just seen, and I mean, Kellie did some great work in the Assange campaign, and I worked on it as well. And, you know, Assange, at the end of the day, was pursued relentlessly because what he did was to expose serious wrongdoing by the United States in theatres of war, Iraq and Afghanistan in particular. And as Bob Carr, the former foreign minister, has said on a number of occasions, this is what upset the Americans. And he's right. And it also, of course, upset the Australians. And that's why you've seen this outpouring in the last few days from the usual sources, you know, the reliable defence security establishment sources like Peter Harcher and Peter Jennings and others complaining bitterly about the reception that Assange has got in Australia. But his case, I think, illustrates the fragility of freedom of the press and freedom of speech when it comes to US-Australian alliance issues. And it's only going to deteriorate in the context of AUKUS. We've seen the David McBride case. We saw the Bernard Collaery case. What those cases had in common was this. The Australian Parliament passed a number of years ago now when the Howard government was in office, but it was supported by the Labor Party, the National Security and Information Act. This act allows a Commonwealth to ensure that certain evidence never sees the light of day, and I mean light of day. It can, and it did so in the Collaery case, it did so in the context of McBride, make applications to the court so that certain evidence could only be heard in secret. Furthermore, having experienced this, been on the other side of it myself in the Melbourne terrorism trial in 2008, the defence doesn't get to see this material either. And so this secrecy cloak is thrown over much of what we would otherwise see. And it generally is used not for the purposes of protecting Australia's security, but in my view, often used to cover up, and that's in no way being conspiratorial, but cover up wrongdoing and those responsible for wrongdoing. In the case of Collaery, of course, it was Alexander Downer who willingly and knowingly authorised the bugging of the East Timorese cabinet room, the poorest nation in the world. And of course, would have had concerns, as would DFAT, as would Defence, as would ASIS, had concerns about the material that might emerge in a criminal trial involving Collaery if it were public. That act is a very, very useful tool that's used by the security establishment to ensure that we don't fully understand the workings of the security state and the defence establishment when it comes to alliances. The second aspect of that is the fact that the United States has established a very dangerous precedent in the Assange case. And just because the matter's been settled, don't think it won't happen again. Australia and the US and other countries condemned China for introducing a security law in the context of Hong Kong, which would allow for what we call extraterritorial reach. In other words, a Chinese citizen who made statements while living overseas, which were critical of the regime and critical of what was happening in Hong Kong, could be the subject of extradition to China, or a request for extradition. What the United States did in the Assange case was use domestic espionage laws for the first time to seek to jail for over 170 years a person who, one, was not a US citizen, and two, who did not initially publish in the United States. This was a very, very dangerous case of overreach. And in one sense, the US got their man. Assange was firstly in the Ecuadorian embassy for 7 years, and then, of course, in the maximum security hellhole that is Belmarsh prison. And, of course, they got a conviction at the end of the day, albeit tokenistic. So that issue of freedom of speech and freedom of the press in the context of defence and security matters is very, very telling and very pressing as an issue for Australians. The other difficulty in Australia, of course, is we do not have a National Human Rights Act, so that freedom of speech is not protected. In the United States, the reason why prosecutors did not go after the New York Times and other publications which published the Iraq war logs and the Afghanistan material was because they had a watertight freedom of speech defence. Freedom of speech in the US context has a very, very broad connotation, much broader than in Australia, which is why you see Trump get away with statements about judges and witnesses that if he did it in Australia, as Kellie and any other lawyers know, he'd be locked up for a considerable period of time on multiple contempts. But what happened in the Assange case, which was troubling, was that, and it was, I think, one of the key turning points, was that the Americans said that Assange did not have, as of right, the First Amendment defence. Because he was a non-citizen, would have to apply for it. So you can imagine an Australian journalist or publisher living in the United States, revealing or publishing material which the United States said was in breach of espionage legislation or other forms of national security legislation, and not being able to use a critical defence simply because they weren't a citizen. In the context of Australia, it's not much better because we don't have a broad human right, freedom of speech, which all of us would enjoy. We do if we were Canadians, we do if we're New Zealanders, we do if we're in the UK, but we don't in Australia. That means that, again, Australians and Australian publishers, journalists, and anyone else for that matter, who publishes material or provides material to journalists, which the government deems to be not in the national interest, which of course is extraordinarily broad, or which in some way undermines the security of Australia, would find themselves with very few defences, if any, in the context of any criminal prosecution. So they're two major issues which emerge from the AUKUS arrangement. The third issue really is a surrender of sovereignty, which Richard and Brian and Alison have all focused on. That's more nebulous in the sense of the law. The nebulous nature of it lies in the fact that it is really a sort of international law issue, and of course, sadly, international law is not particularly effective because it's unenforceable. But what Australia is doing by, hooking up with the UK and the US is effectively tying itself into strategies whereby if the US, for example, committed serious human rights abuses in the context of defending Taiwan against China, Australia is tied into those by virtue of its alliance and by virtue of its containment strategy and by virtue of it assisting the United States. You can aid and abet genocide. You can aid and abet war crimes and crimes against humanity. We're already seeing this in the context, and I think it's been raised earlier, of weapon supplies. Not just weapon supplies, but software, multiple use devices and software that can, one of the uses of which is in as military equipment. And we're seeing it in the context of Israel. For some bizarre reason, Australia thinks that it, like the United States, and partly through its alliance with the United States, has to support Israel in this conflict. You've heard Richard Marles, who of course is deeply embedded in the Washington establishment and a favoured son. You've heard Richard Marles say, oh, well, we haven't allowed any defence exports since the start of the conflict under the exports legislation, which I'll now turn to quickly. So under the defence exports legislation, there is a series, well, there is criteria which is used. There are criteria which are used. And one of those criteria goes to the impact of human rights. Obviously more on it in the breach. But one of the difficulties with this legislation is that it's effectively unchallengeable. None of us here could challenge it because these decisions are all made in secret. They're not amenable to judicial review because of the secrecy that attaches to them. You don't know what the decision is and how it was made. But Australia kids itself in a defence exports legislation, deliberately so. In this sense, you can, for example, export to a third country, and that knowing that those components will be then shipped to Israel. You can make software which has multiple uses. You have an Israeli client. Interestingly, there was a company. I think Kellie, you might have looked this up for me as well. There's a company here in Tasmania, which proudly announced that one of its products was a drone, I think, or a component for a drone. Proudly saying that the IDF was one of its key clients. Within a few days, I gave it to a local journalist here. Within a few days, it had gone, vanished from the website. They're just a good little, tech startup trying to get going in the Australian environment. But the important point is that this legislation is really weak. It's nebulous. It allows a lot of wriggle room, and most people wouldn't know that the defence exports legislation exists. So let me wrap this up because we're running out of time, but let me wrap this up by saying this. The legal issues which emerge from Australia's preparedness to maintain a position with the United States and with the UK for that matter mean that legislation and the way in which legislation operates and the way in which the law operates is effectively to say that the security state and the defence establishment are off limits. It is extraordinarily difficult to criticise them. It is extraordinarily difficult to challenge decisions made both by virtue of secrecy provisions. You can contrast that, for example, with what happens in South Africa. You can contrast that with what happens, for example, in Ireland, where there is much greater and there's greater transparency and greater discussion about these matters because they are not wedded to what you could say is the most brutal alliance in the world in terms of the number of people, directly and indirectly, including through Israel, that are killed each year. So look, Kellie, I'll end it there and happy to take questions.